Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. And today, in litigation news, the Kerala High Court stays administration's notice to demolish the traditional coastal dwellings. Two residents of the Karavati Island living in coastal areas filed the petition challenging the show cause notices issued to them by the Lakshadweep administration. The Kerala High Court on Tuesday restrained the Lakshadweep administration from demolishing the coastal dwellings belonging to two residents of Lakshadweep. In the case of Ubaidullah Kunyamakada versus the Administrator, Union Territory of Lakshadweep. Single Judge Justice Raja Vijay Raghavan B directed the administration to file its counter affidavit within 4 weeks on a plea by the residents challenging the show cause notices issued to them by the Lakshadweep administration. The court directed that, till such time, the respondent shall not make any attempt to interfere with the possession of the petitioners over the properties, nor shall they demolish any structures situated therein. Two residents of the Karavati Island living in coastal areas filed the petition challenging the show cause notices issued to them by the administration, stating that their houses are liable to be removed since they were allegedly constructed without the diversion certificates as per the Lakadu, Minicoy and Amini Islands Land Revenue and Tenancy Regulation 1965 and in contravention with the Integrated Island Management Plan IIMP. Advocate R. Rohit, appearing for the petitioners, submitted that the dwellings belonging to the petitioners were constructed by their fathers in the years 1960 and 1963 on the land belonging to them. The administration issued show cause notices to the petitioner stating that the buildings are without any diversion certificates as per section 20 subsection 1 of the regulation. The administration further contended that the structure lies within 20 meters from the high tide line, which is declared as a no development zone. Advocate Rohit argued that the regulation is a prospective enactment that does not explicitly or by necessary implication provide for any retrospective operations. Hence, he submitted that the issuance of notice under any provision of said regulation towards a construction which was completed prior to the commencement of the regulation is not maintainable. Further, he submitted that as per section 20 of the regulation, if a person is holding any allotted land and wishes to use it for any other purposes, he shall apply for diversion. But since the disputed land is not an allotted land, he contended that the certificate under this regulation would not have any relevance in this case. The question of applicability of diversion certificate is currently pending in petitions filed before the Kerala High Court. The court had earlier granted for interim orders in favor of the petitioners in such cases. Regarding the allegations that the dwellings fall in the no development zone, he stated that as per the relevant notification, no authority is empowered to demolish the existing dwellings built prior to the existence of the land laws and the notification of the IIMP, that is, the Integrated Island Management Plan. Furthermore, he pointed out that due to the sea erosion, the area falls within the zone and that has changed over time, especially since those dwellings were built nearly 60 years ago. Therefore, no street jacket formula must be applied in this regard. The petitioners further submitted that Lakshadweep is a scheduled area declared as per the Scheduled Areas Part A, Order 1950, and inhabitants or islanders are commonly treated as scheduled tribes as per the Constitution Order or 95. The petitioners contended that the Lakadu, Minicoy, and Amindivi Islands Protection of Scheduled Tribes Regulation 1964, promulgated by the President under Article 240, is intended to prevent the transfer of land from scheduled tribe to non-scheduled tribe. The petitioners admitted that they are challenging only show cause notices and that the administration gave them only 5 days of time to reply for the same. However, they contended that even the show cause notice is a clear infringement of the constitutional right of scheduled tribes to possess and occupy the land with dwelling houses. Pertinently, the petitioners pointed out that the impugned orders are issued by block development officers and they are not competent authority as per 2 subsection 6 read with section 4 of the regulation. However, Advocate S. Manu, standing counsel for the respondents, submitted that the powers have been conferred on the block development officer to issue notices in this regard. He contended that the petitioners can appear before the fourth respondent and state their version and produce records, and appropriate orders shall be passed. Justice Raja Vijay Raghavan, however, issued the interim order staying any demolition of the petitioners' dwellings, noting that now that the petitioners have been served with the notice, they can very well appear before the respondent, who is the block development officer, and raise all their legitimate legal contentions, including the lack of authority of the fourth respondent in issuing such notice. The fourth respondent shall consider the materials produced by the petitioners and take a decision in accordance with the law. With this, I come to the end for today's discussion. Thank you.